Good morning, everyone. Welcome on this platform of Gyan Sudha Success Sathi channel. I'm Dr. Vineeta Srivastava, Associate Professor in Social Work. And my today's session, that is Witch Hunting Part 2, basically focuses on the legal purview we have in India to deal with the problem of witch hunting. This video is in continuation with my earlier video Witch Hunting Part 1, already uploaded on this channel. In Witch Hunting Part 1, we have analyzed the problem of witch hunting in India and its grave consequences. We have also understood the concept of witch hunting. We have analyzed the background and reality of the practice of witch hunting in India. We have also analyzed the envisaged rules and actual practices of the institutions dealing with witch hunting in India, including family, neighborhood, panchayats, police, judiciary, and media. In today's session, we will find out what legal remedies are available in India to deal with this inhuman practice of witch hunting. It will be followed by the conclusions and suggestions and questions and queries. Let me remind you that witch hunting is an important topic for the UPSC Civil Services examination, particularly for the general studies papers. Those interested in society, social issues and problems, values, beliefs, and ethics, and policy for social welfare will find this video and this topic very helpful. Let us start our discussion by analyzing a few more definitions on witch hunting. In British English, witch hunting is described as an attempt to find out and punish a group of people who are being blamed for something. This something may be anything like falling health of somebody, infant mortality, death of animals, etc. Anything causing deteriorating impact on the society and the members of the society. Now, let us take a more exhaustive definition of witch hunting. In American English, as per Webster's New Word College Dictionary, 4th edition, witch hunting is described as an investigation carried out ostensibly to uncover disloyalty, subversive political activity, etc., usually conducted with much publicity and often relying upon inconclusive evidence and capitalizing on public fear of unpopular opinions. This is a very important definition which makes various aspects of witch hunting clear, as we have also analyzed in our earlier video. It says that witch hunting capitalizes on public fear. It says that witch hunting often rely on inconclusive evidence. It says that publicity and public opinion is very important in the practice of witch hunting. So, let us focus on the legal purview that is available in India to deal with this inhuman practice of witch hunting. Though we do not have a national level legislation to deal with this menace, still our basic institution of law, that is, the Constitution of India, incorporates various provisions against the practice of witch hunting. The most important are the fundamental rights granted under the Constitution of India. We have seen that witch hunting is an extreme example of gender inequality. And in our Constitution, Article 14 provides equality before the law. Article 15(3) is also a very important article. It says that nothing in this article shall prevent the state from making any special provision for women and children. Means positive discrimination is allowed. And when it is obvious from various case laws and various practices being reported in newspapers, there is a need of time to provide positive protection to women and children against this inhuman practice of witch hunting. Article 21 is also a very important article. It says that no person shall be deprived of his life and personal liberty except according to procedures established by law. So these three fundamental rights provide us the basis against this inhuman practice of witch hunting in India. Then we also have Article 51 and Article 51A, which are incorporated in the directive principles of state policy under the Constitution of India. Article 51 says that the state shall endeavor to foster respect for international law and treaty obligations in dealings of organized peoples with one another. And Article 51A says that it shall be the duty of every citizen of India to develop a scientific temper, humanism, and spirit of inquiry and reform. It says that it shall be the duty of every citizen of India to abide by the Constitution and respect its ideas and institutions. We also have the national legislation known as the Protection of Human Rights Act 1993. And witch hunting is a practice which violates the provisions of the Protection of Human Rights Act 1993. Guwahati High Court has observed that branding of a man or a woman as a witch and then resorting to witch hunting is the most dehumanizing act and is one of the worst forms of human rights violations. In India, we also have the Scheduled Castes and Scheduled Tribes Prevention of Atrocities Act 1989. The practice of witch hunting violates various provisions of the Scheduled Castes and Scheduled Tribes Prevention of Atrocities Act 1989. We have also analyzed in our earlier video that the prevalence of witch hunting practice is much high in the scheduled castes and scheduled tribes. So the provisions of this act may be used to provide protection and immunity against the practice of witch hunting in India. Witch hunting involves acts which are punishable under the Indian Penal Code 1860. Hence, the provisions of the Indian Penal Code 1860 can be used as an alternative to provide protection to the victims of the practice of witch hunting. The different sections invoked in such cases are Section 302, which relates to charge for murder. Section 307, which is relating to attempt for murder. Section 323, relating to hurt. Section 376, which penalizes for rape. And Section 354, which deals with outragging a women's modesty. Let us focus on the timeline of the important state laws to control and eliminate the practice of witch hunting. Bihar is the first state in India to enact the Anti-Witch Hunting Act. In 1999, Bihar enacted the Prevention of Witch or Dian Practices Act, which was eventually adopted by Jharkhand as well in 2001. So, Jharkhand established Anti-Witchcraft Act in 2001 to protect women from inhuman treatment as well as to provide legal recourse to abuse. Assam is the state which also took initiative to prevent the practice of witch hunting. In 2001, Assam police had introduced Project Prahari, which was a community project by the police against killing of women after branding them as witches. In 2005, Chhattisgarh enacted the Chhattisgarh Tonahi Pratarna Nivaran Act. In Chhattisgarh, Tonahi is the word used in local language for a witch. As far as Rajasthan is concerned, the initiative to control the practice of witch hunting was taken in 2006. In 2006, Rajasthan government passed Rajasthan Women Prevention and Protection from Atrocities Bill 2006, which makes it illegal as well as punishable for calling any woman as Dian or to accuse a woman for practice of witchcraft. It takes a long time as well as process to convert a bill into an act or legislation. So the next state is Odisha. In 2013, the Odisha Prevention of Witch Hunting Prohibition Act 2013 was approved. It was notified on February 2014. Let us see what next in the struggle of prevention of witch hunting practices in our country. Assam Witch Hunting Prohibition, Prevention and Protection Bill came into picture in 2015, but it was approved by the President on 13 June 2018 and was notified on June 29, 2018. We have seen in the earlier slides that the Rajasthan Women Prevention and Protection of Atrocities Bill was passed in as early as 2006. But the Prevention of Witch or Dian Practices Act was enacted in 2015 in Rajasthan. The act was approved by the governor and notified on April 24, 2015, and it came into force from August 17, 2015. So Rajasthan became the fifth state in the country to have a specific legislation to control the practice of witch hunting. In continuation to the act, that is the Rajasthan Prevention of Witch Practices Act 2015, the Rajasthan state made the Prevention of Witch or Dian Practices rules notified on January 7, 2016. So just in continuation to the act, rules were also framed by the government of Rajasthan. Apart from all the efforts described earlier here, at the national or state level to prevent the practice of witch hunting, we also do have international laws to control and eliminate the practice of witch hunting. And the Indian government has an obligation to protect women from discrimination on the basis of gender and also provide basic legal rights and security granted by different international treaties, covenants, and laws. The first and the most important of the international laws in this context is the Universal Declaration for Human Rights 1948, which, being international law, provides protection against any discrimination and promotes equality before law and confirms right to life and liberty to every human being. Now see the next. Followed is the International Covenant on Civil and Political Rights, popularly known as ICCPR. It, being an international body, promotes equality between men and women by ensuring rights to men and women in civil as well as political sphere, and prohibits others from subsuming anyone's basic rights. It explicitly mentions prohibition of cruelty, inhuman and degrading treatment, and by associating with the covenant, it is obligatory for Indian government to implement these rules as well. India has also signed Convention on the Elimination of All Forms of Discrimination Against Women, popularly known as CEDAW, CEDAW, 1993. And India had agreed to eliminate discrimination and social cruelty against women by signing on this convention. The convention explicitly provides that the states should take appropriate measures to modify the social and cultural patterns of conduct of men and women. Apart from the international instruments, covenants, and legislations to protect women from the practice of witch hunting, we have also seen in our society the initiatives of different NGOs to control and eliminate the practice of witch hunting. I have very specifically mentioned the actions of some of the NGOs regarding this. The first one in this regard is Partner for Law and Development NGO. Partner for Law and Development considers women's rights as an integral part of the society and protects women's rights from getting violated through families on basis of sexuality, culture, caste, etc. Many other NGOs are also working for prevention and protection of women from social evils like witch hunting. One among those is Rural Legislation and Entitlement Kendra, which had also filed a PIL, public interest litigation, in Supreme Court relating to abuse of women in the name of witch hunting on behalf of 1,000 rural women in Jharkhand who were victimized of witch hunting. A bill, Prevention and Protection of Witch Hunting, has been drafted by the members of Human Rights Defense International, which is still pending. It aims at establishing national legislation relating to witch hunting. So after analyzing the legal purview which is available in our country to fight this practice of witch hunting, let us see what have been the conclusions and suggestions. We have concluded that we must recognize that witch hunting is very real and that women of Adivasi, Dalit, and other women in many parts of India are continuously being victims of this practice. We've concluded that we definitely need a national level legislation that penalizes witch hunting. Strict enforcement as well as implementation of anti-witchcraft laws by the states will work to prevent witch hunting practices. We need to sensitize the institutions involved in and responsible for the enforcement of the related laws. Training and sensitization sessions are indeed need to be conducted on regular basis. We've concluded that patriarchal attitude of the society, vested interest, personal gains are some of the important reasons for the prevalence of the practice of witch hunting in India. We have analyzed that there have been issues with criminal justice administration which need to be worked on. We have seen that socio-cultural deprivation is there and we need to work or attack on this deprivation. As a social evil, witch hunting is difficult to tackle because the motivation of such action is often rooted in the traditional, spiritual, and cultural belief systems of the communities. The state and NGOs need provisions for providing rehabilitation, relief, or any form of compensation to women after they have found to be the victims of the practice of witch hunting. Comprehensive approach consisting of legal remedies, psychological support, economic empowerment, education, persecution of the perpetrator is immensely required to deal with this practice of witch hunting. If we talk about the remedial measures, we come to know that improving access to healthcare by ensuring that mental health care and support reaches villages with the appointment of psychiatrists and psychologists at the block level is required. Supportive awareness programs and campaigns to aware people to eradicate the practice of witch hunting need to be conducted. The youth, in particular, need to be made aware about this practice and the legal and social impacts of the same need to be made clear. Let us have a look at the questions which can be asked regarding the practice of witch hunting. The first question in this regard is, what are the reasons for the prevalence of witch hunting in India and what needs to be done to tackle this menace? The next question is that how many states have witch hunting prevention legislation? Name those states. We require a national level legislation to deal with the problem of witch hunting in India. Comment on this statement. What measures would you suggest to tackle the problem of witch hunting in India? And the last question in this regard is, what legal guards do we have to deal with the cases of witch hunting in India? So these or like questions may be asked in various competitive exams, in written tests as well as interviews regarding the practice of witch hunting. If you have any queries or questions, you may ask while using comment box. The most interesting fact about this practice of witch hunting is that together we can make the difference in the society. We make the people of the society aware of the practice of witch hunting and the politics prevailing behind the scene. A lot can be done to save the victims. This slide shows some of the resources I have used for my research as far as this topic of witch hunting is concerned. So students, in this video, we have come to know about the legal framework available in our country to deal with the practice of witch hunting. We have gathered information about the international covenants available to deal with the practice of witch hunting, along with the constitutional provisions under the fundamental rights, as well as directive principles of the state policy, which can be used. We have also concluded that we can use the provisions of Indian Penal Code 1860 as well as the national legislations like Human Rights Protection Act 1993 and the Scheduled Castes and Scheduled Tribes Prohibition of Atrocities Act 1989 can be used against the practice of witch hunting. We have come to know about the initiatives of various NGOs fighting against the practice of witch hunting. We have also gathered information about various state laws available in our country against witch hunting. And we have also concluded that we definitely need a national level legislation along with strict enforcement and sensitization and training of persons belonging to different institutions relating to the practice of witch hunting if we want to control this menace. I hope that this video has given you some new insights about this inhuman practice of witch hunting. I hope that this will help you in your examination also. And also, you will be able to not only spread awareness, but will also take a stand against witch hunting. All the very best to you, and thank you very much.